Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about summary judgment, and we got some interesting things going on with a couple of people. I know a lot of you are following Sabrina and the Winslow's case, and let's go right into it. Okay, so this presentation is called Foreclosure Defense Summary Judgment, the Finish Line. So the typical life cycle of a lawsuit in foreclosure case, and this is where the plaintiff is the homeowner filing a quiet title or a complaint against the bank. Let's look at it that way. Okay, the complaint is filed, and then dispositive motions are filed, which is like a motion to dismiss. The case survives dismissal with a court order, and then the other side has to file an answer, and then discovery starts, and you get discovery. And then after you've gotten discovery, if you have enough information from discovery, you can file what's called a summary judgment. And then after that, the decision is often without a hearing by the judge based on the information in the summary judgment itself. Okay, so what a summary judgment really is not, it is not a long legal essay. It is not a repeat of the complaint. It is not a place to argue feelings or fairness. A summary judgment is proof, not persuasion. It asks one question only. Is there any genuine dispute of material fact that requires a trial? If the answer is no, the court must rule now. The three pillars of winning a motion for summary judgment. Number one, undisputed facts. Admissions, RFAs, which is request for admissions. Interrogatories, produced documents, recorded instruments, sworn declarations, okay? These are considered facts and not speculations or no hearsay, no theories. The law that attaches to those facts. For instance, a forged instrument is void ab initio. Unrecorded liens have no enforceability or security interest. Destroyed note equals no enforcement rights. The wrong party equals no standing. The law follows fact, not the other way around. So, Rule 56 discipline means separate statement of undisputed material facts. You want to pinpoint citations with clean exhibits, no emotional language. Judges trust clean Rule 56 papers. So what do judges look for in a summary judgment, especially from a pro se litigant? Judges do not hold pro se litigants to lower evidentiary standard at summary judgment. They look for the same things they expect from attorneys: undisputed material facts, admissible evidence, and a clear connection between the facts and the law. Argument alone is not enough. Opinions, beliefs, or accusations do not create a genuine dispute. What matters is the paper record, admissions, sworn discovery responses, and documents that speak for themselves. A well-organized, rule-compliant summary judgment motion allows the court to decide the case without a trial. Why most people lose at summary judgment? Be honest, this is where people will learn. They argue instead of prove. They rely on belief instead of evidence. They skip discovery. They dump documents without tying them to facts. They think volume equals strength. Volume only matters when it's organized, guys. What the finish line looks like. A good motion to summary judgment shifts the burden to the bank, locks the record, forces admissions, eliminates credibility disputes, and makes trial unnecessary. Even if the court grants it in part, that's still a win. Liens narrowed or eliminated, claims are dismissed, leverage is created. Real world examples. Let's talk about Sabrina's case, where it says, in one case, the servicer admitted the original note was destroyed and that no deed of trust was ever recorded to secure the replacement note. There was nothing left for a jury to decide. The most important takeaway: you don't win foreclosure case by talking louder. You win it by building a record the court cannot ignore. Yes, discovery is the key that unlocks the evidence. Complaints start cases, arguments fill briefs, but discovery creates proof. It is where stories turn into sworn statements, stories turn into sworn answers. Assumptions turn into admissions. Missing documents become undeniable. And confidence collapses when records don't exist. That is why the other side fights some discovery so hard, because once discovery is done, the case stops being about persuasion and starts being about the facts. Everything you're seeing now, summary judgment strength, weak opposition, pressure, tactics, failing, traces back to one thing: discovery forces the truth into the record. That's the real turning point. What judges also notice about pro se summary judgment filings: judges notice professionalism. They notice whether a pro se litigant follows basic formatting rules: correct font size, paper space, proper spacing, readable margins, and compliant citations. They notice when cases are properly italicized, when there is a clear table of contents and table of authorities, and when the brief is organized instead of chaotic. They also notice tone and clarity. A filing should not read like a child wrote it, but it should also not read like an overly academic law review article. The best summary judgment motions are written in plain, precise language that makes the facts and law easy to understand. When a judge can follow the argument without effort, credibility increases. Both summary judgments do the things judges quietly reward. They don't follow the rules, font spacing, structure. They are organized and readable. They cite authority correctly. They use tables and let the judge navigate quickly. They are written in plain professional English, not rambling and not academic, and they respect the court's time. That combination signals something very important to the judge. The litigant understands what summary judgment is supposed to look like. Judges may never say this out loud, but it affects how carefully they read, how much trust they place in the record, and how comfortable they feel ruling without a hearing. So yes, when the Winslow's and Sabrina's motions are read, they won't be read as pro se papers. They will be read as serious Rule 56 submissions. So let's take a look at these summary judgments that the Winslow submitted and Sabrina submitted, so you guys get an idea. We'll go through the highlights of these cases, guys, and if you guys want to see them, you can join my Facebook page where it's listed. Both of these summary judgments you can view on the website, or you can send me an email and I will send it to you. But this is the Winslows, and you can see their table of contents has these things. This is properly structured for summary judgment. You have an introduction, statement of undisputed material facts, legal standard, argument, and then for the argument section, you have subheadings like the plaintiffs have established a period title, B, the 2019 deed of trust is void and cannot create an interest in the property, C, the 2024 assignment is void and cannot support defendant's claim, D, no genuine issue of material fact exists, conclusion, and then we have what's called an exhibit index. And then we have our table of authorities and statutes. And so we basically can go through this kind of quickly so you guys can kind of see some highlights here. And of course you want to have your case law. You want to make sure your case law is on point and that it exists. And so to just kind of go through this with the Winslow's case, let's kind of go down here so you guys can see some things here. Let's see. The statement of undisputed material facts is pretty important because this is really what makes the difference in the argument. And starting with number 2, where it says defendant asserts that an adverse interest in the property through a deed of trust recorded on September 20, 2019, despite plaintiff's allegation that the document is a forgery. Defendant admits it cannot produce the notary journal or verify verification records for the purported signing of the 2019 deed of trust, asserting that the documents were destroyed in a hurricane. And this is not a hurricane state, guys. Colorado hasn't had a hurricane the last I checked. Defendant cannot identify any policy or procedure for verifying borrower's signatures before recording a deed of trust, and gave only a conclusory reference to HUD FHA underwriting guidelines without identifying any specific process used to prevent forgery. Exhibit A, interrogatory number 10. So they got their discovery back, right? And so now you have to put it together and explain why they admitted it. They admitted that they didn't have that in place. Defendant has admitted that it cannot produce a complete chain of endorsements for the promissory note and provide no evidence showing the note was ever negotiated, delivered, or transferred. Exhibit C, RFA number 8. And RFA means request for admissions. That's where they have to admit it or deny it. Number 6, defendant admits that there is no FHA insurance certificate, no HUD endorsement, no record of FHA case number, no record of paying FHA insurance premiums, and no evidence that the loan was ever FHA insured. Exhibit C, RFAs 11 through 14. Defendant admits that the documents in the loan file contain inconsistent FHA case numbers and some contain no case number at all. Defendant admits that the March 8, 2024 assignment was prepared by its litigation counsel, Messner Reeves, rather than by MERS. Defendant also admits it cannot produce any written authorization or power of attorney allowing Messner Reeves to execute documents on behalf of MERS or OCMBC. Defendant admits that it has no evidence of physical delivery of the promissory note to any entity, no evidence the note was ever sold or securitized, and no identifiable business purpose for assigning the deed of trust from OCMBC to itself. And guys, OCMBC is the bank, in case you're wondering, or it's the servicer. Exhibit A, interrogatory 12. Exhibit C, RFA number 25. So you have, when you're doing your statements, you have to also put in there where you got this from so that the judge can look at those exhibits. These admissions are material and dispositive because now they show that defendant cannot authenticate the deed of trust as required by CRE 901A. That's the Colorado Rules of Evidence, 901A. Cannot establish ownership of the promissory note as required under Colorado law. And then, of course, you got to have your case law in there to back you up. Legal standard. There's the legal standard section, guys. The argument. Plaintiffs have established superior title, which you have to win a quiet title action, you have to do that. Let's see here. The deed of trust is void and cannot create an interest in the property. That has to be in there as well. And then let's take a look here. Another important factor is the exhibit index, which is at the end of the motion itself. And as you can see, Exhibit A is the defendant's responses to interrogatories dated December 10th, 2025. Okay, and then Exhibit B would be the defendant's responses to requests for production of documents. Exhibit C is defendant's responses to requests for admissions. Exhibit D is the HUD FHA correspondence confirming that there is no valid FHA case number that exists. Exhibit E is the assignment of deed of trust recorded March 8, 2024. Exhibit F is the December 2nd, 2025 correspondence from Messner Reeves, which was that extortion letter we talked about. We wanted to put that in here so the judge would see it. Okay, so those are the exhibits that are in it, and then the actual exhibits are after that. The exhibits responses to interrogatories, which they gave to them. And you can see here, they object to answering it, but then they answer it. You see that? I don't know about this law firm. It's not real smart by, if they object to it, but then answer it, guess what? Their objection gets thrown out. So they pretty much admitted to everything. And again, guys, this is all on the public docket. Or if you want to look at it, you just let me know and I'll show you. The other thing I wanted to show you, and I know we don't have a lot of time to go over Sabrina's, but hers is pretty important too. Hers was filed yesterday on the 15th as well. Sabrina Kohler versus Broker Solution, doing business as New American Funding, or NAF. And then she has a slightly different table of contents. Her stuff has been going on for quite some time. Let's see. If you look at Sabrina's case, it's in PACER. There's the case number. If you guys have access to Pacer, you can follow her whole case. You see she filed her complaint July of 2024. And if you go down, her case was amended a couple of times. And then there was a motion to dismiss, which survived. All her claims survived the motion to dismiss. And then you can see right here, the last thing that was filed on 12/15 was her motion for summary judgment. Okay, so hers is a little bit longer and more detailed than the Winslow's, because the Winslow's only had quiet title to argue, whereas hers has everything to argue. So you can see her argument has a much larger subsection. Count 1, slander of title, and then the subheadings under that, A, B, C, and D. Count 2, fraud, subheadings under that, A, B, C, E, and F. Count 3, forgery, A, B, C, and D. Count 4 and 5, unjust enrichment and conversion. And then you can see count 6 and 7, breach of contract, breach of implied covenant of good faith and fair dealing. And then her last counts is quiet title and declaratory relief. Conclusion, prayer for relief, exhibit index. Now this motion, if you get it on Pacer, is 238 pages. We don't have enough time in this video to go over it all, but I'm telling you, it's a good read, guys. If you want to see it, it's amazing. And a good case to read that was cited a lot was, let me show you which one that is, right here. Bellastri versus Aquin Loan Servicing. Very important case. It was cited a lot, and same thing with the Celotex Corp versus Catrit. Those were cited a lot in this motion for summary judgment. But again, it's a lot the same. It's the same stuff, but different information, obviously, because they're different circumstances. But you guys get the idea. And then at the end, again, the statement. Let's see here. Her statement of undisputed material facts is much longer and more in-depth and detailed than the Winslow's because of this reason. And again, this is not something we can go over in one video because it's just too much information. But you'll see that if you can read this while I'm kind of going along here, you can see what it says. Defendant admits. Defendant admits. That's so important. Sabrina's case, a lot of it stems from the paperwork they sent to her and the request for a production of documents, which they sent her a boatload of, which she's using against them now. Another thing interesting in these exhibits was when they gave her copies of all her servicing records, everything in the servicing records pretty much substantiates her claims. And it's important that when you get discovery, you get copies of all your servicing records, because then you can prove your point. If that the servicer abused you or lied to you or did things with your payments, you get your servicing records and it will show all these things. Sometimes they'll give you servicing records and they will black it out or redact it without explanation. And when they do that, 9 times out of 10, they're hiding something, guys. Hiding. So that's just so you know, you go through all these servicing records and see what has been redacted by the other side. Example here on the servicing records where it says here on 5/27/22, returning borrower's check as it is insufficient to... Okay, well, it's saying insufficient to cure the delinquency. But you know what? She called them and asked them how much she should send them to cure the deficiency. And she sent them what they asked for. It was like $9 grand. And then they wanted to foreclose. And then if you look at the next page, look, oops, they redacted all this stuff. They don't want us seeing that. Well, you know what? That's baloney. You know what? You want to know what's in there. Probably stuff they don't want us seeing, but it's not going to stop her summary judgment, and the judge is not going to be amused by this. Here you can see she sent them a cashier's check for $9,083.59. And they should have applied it to the loan and made her current, but they didn't do that. And see, it says not enough to reinstate the loan. So they told her to send $2,000 more, and she did, and they kept that. And they never even applied it to the loan, which is wrong. That's unjust enrichment right there. Okay, guys, I hope this video was informative, and if you have questions, you can send them to me. My email address is the number 4, foreclosurehelp777@gmail.com, or you can leave a comment below, or you can join my private Facebook group and read both of these motions which are listed. And as always, everyone, have a Merry Christmas and a blessed day.